listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Yes, virtually.
Yes, virtually.
I'm on the road.
One of the few times we are both on the road, both in hotel rooms at the time of recording the podcast.
Yes, and I won't tell you where I am, but I will tell you my hotel room is disgusting.
I won't tell you where I am, but I will tell you my hotel room is nicer than some I've stayed in, but not among the nicest.
This is the worst one I've been in probably 10 years. Just the floor is filthy. It feels like the murder hotel. I feel like I'm in a Quentin Tarantino film. I was deceived by the website and I stayed someplace that I wouldn't normally. I was considering staying in one of those Fairfield by Hilton or something like that. And then I thought, you know what, I'm going to continue on to the next city and not stay at the Hilton because I don't want to be supporting the Hilton right now. And so, yes, here I am in a fourth grade hotel chain.
I always compare every hotel that I ever stay in to the hotel at the Miami airport.
Oh, okay. Yeah.
That was the worst hotel I ever stayed in because it was literally a prison cell.
Yeah, I know. You sent me photos. It was unpleasant.
It made it look in the pictures online like it had a window. It had curtains over a concrete wall.
Good. Yeah. Well, maybe there was one room in that hotel that had a window. I just remember looking at the toilet you had there looked like a prison toilet.
Yep.
It's like a old school handle flush with 50,000 pounds of water pressure.
Yep. The whole thing.
Most people don't go there as a destination hotel. So
no,
if you can make it through the night.
I barely did.
Yeah. Well, no thanks.
Anyway, we have a lot to talk about today.
Yep.
Holy moly. The first thing we talked about last week, feels like yesterday, feels like 10 years ago. We talked about the Supreme Court of Canada granting leave on a case involving, refusing leave on a case involving impaired driving issues. This week, they granted leave on a case involving impaired driving issues.
What's with them? It's like they're bipolar at the Supreme Court of Canada.
Yeah, it is. This one's very interesting, though. It has to do with the offense. So remember how it used to be, you had to be driving at or over 80 milligrams %, and somebody's death has to ensue as a result of your elevated blood alcohol level was the old offense.
Yeah.
Now the new offense is driving at or over 80 milligrams % or with an elevated blood drug concentration, and somebody dies, period. So, like, if you're, for example...
Oh, yeah. We talked about this when it came out.
Yeah, if you're stopped at a stoplight and and you're drunk.
You're drunk and you're rear-ended by somebody who's drunk and somebody died.
You're liable for the like higher consequences of the causing death offense, even though there's no causation element there.
For the guy who's drunk behind you who drove up and hit you and died.
Yes.
Yeah.
Yep. So the Supreme Court of Canada is going to consider that. And the argument is really odd because you'd think that it would be considered as like a proper constitutional issue, like that the offense is unconstitutional on the basis of the fact that, it creates essentially like a de facto absolute liability offense and exposes people to like actual jail consequences when they don't have the requisite mens rea.
There's no mens rea except the standard mens rea for driving with a elevated blood alcohol concentration, which is you made the decision to drive after drinking.
Right, which you don't get. You don't get the same exposure to penal consequences. So, this is a case of Kelly. It's from the Ontario Court of Appeals. Supreme Court of Canada is going to hear it. And essentially in Kelly, Mr. Kelly argued that interpretively, not constitutionally, the criminal code is unconstitutional as it's written, but interpretively, Parliament intended that provision, despite rewriting it to be pretty explicit, to mean still that there was a causation element, because otherwise it would be unconstitutional. And so it has to be interpreted in a way that makes it constitutional. Essentially, like really, it's like a constitutional argument asking the court to read in as a remedy, but like packaged up as just a statutory interpretation argument.
Do they make this like a Section 7 argument, or how do they do that?
No, they make it as a statutory interpretation argument. So the accused in that case, Mr. Kelly, said, no, I think you have to interpret this in a way that doesn't allow it to create an absolute liability offense. The way the Court of Appeal frames it is paragraph 36. They say, the respondent argues that the interpretation of this provision urged by the Crown, which is exactly how it is written, is tantamount to an absolute liability offense or substituted mens rea. Absolute liability offenses with the possibility of incarceration have been held to violate Section 7 of the Charter, which is why it should be a constitutional challenge. Similarly, the respondent highlights that offenses where the proof of an element of the offense may be substituted for proof of another fact will violate the presumption of innocence guaranteed by Section 11D of the Charter if proof of the substituted fact does not lead inexorably to the conclusion that proof of the essential element exists. And so he says the charter compliant interpretation should be preferred, even though there's no ambiguity in how it's written, right? Like, I know if there's ambiguity, then you can get into whether the interpretation's charter compliant because it's capable of multiple interpretations. But it's very weird.
Yeah. I mean, normally you pose a hypothetical when you're doing one of these charter challenges.
I mean, not always. In this case, you would just do the charter challenge on the basis of the way it's written.
Yeah.
There was in fact.
Why a statutory interpretation instead of a charter challenge?
Probably he forgot to file his constitutional questions notice and decided this was the way to backdoor it.
But they accepted that.
Yeah. But then the court says, no, I don't accept the respondent's argument.
No, I know, but at the Supreme Court of Canada, is it not framed as a constitutional challenge?
Nope. It's framed as whether the Court of Appeal erred in their interpretive exercise. And you know how it's going to go, Paul. You know how it's going to go because every single time the Supreme Court of Canada has had the opportunity to interpret something from C-46, whether it's the benefit of the defense or to the benefit of the Crown, the plain language of what they put in the code is what they say it means.
Well, you and I were in Ottawa presenting, and I don't know if it was before or after us. It might have been after us, but I don't think we stuck around long afterward. But there was that old lawyer for the government who was going, oh, we would never apply it in this way. Like,
and if they suggested more, we'd take them out to the woodshed.
Yeah, that was his woods. Any prosecutor did we'd take them out to the woodshed. Yeah. We've been out in running trials in small communities where there's like no oversight over the prosecutor and there's nobody there to take them out to the woodshed. And the person who should rightly be taking them out to the woodshed is the one who's running the stupid argument.
Yeah, but I took them out to the woodshed. So
well, that's true, but I mean, still shouldn't happen. It still shouldn't happen. But this is like it. Don't go before a parliamentary committee and say, don't worry, we just want to cover this angle, and so we're doing it this way. And anybody who tried to use it this way would be not permitted. Just spell out how you want to use it then, like where it's supposed to be applied. Spell out a bunch of exemptions.
Well, you can also see like clearly Parliament's intent when you have the dangerous driving and the impaired driving offenses, where it's like causing death or causing bodily harm, where the causation element is explicitly written in the legislation. And to say one thing and not say another is to say something.
Yes. Yeah.
Like they say as much when they don't speak as when they do speak.
So where do you see this one going? I mean, they're allowing the hearing to proceed.
The one thing
not beyond cases that should have gone to the Supreme Court of Canada but didn't.
No. The one thing I will say is, the Supreme Court of Canada gets a lot of latitude in stuff they can get away with because nobody can appeal them. I think there is a way, and I'm going to have to brush up on my Supreme Court of Canada rules, but I'm pretty sure there's a way that they can actually convert it into a constitutional challenge.
Oh, I'm sure they could.
Like a reference.
I think any court could. I think any court has the authority and statutorily or just by common law to reframe it as a constitutional challenge. And I've never understood why it doesn't happen. When we were arguing the 7-day window on IRPs for those circumstances where one person was misinformed by his lawyer about the time frame, the other guy was in jail and couldn't file because he was in jail. And the court said to us, well, this could have been a constitutional challenge and maybe something would be different. And I was like, why didn't you just reframe it? Like, you guys are the court of appeal, for goodness sake. Reframe it. Come back and tell us that we need to come back and argue it.
So why the Court of Appeal can't reframe it versus the Supreme Court of Canada can is because the Court of Appeal, in order for you to actually bring a constitutional challenge, there's certain notice requirements to the Attorney General of Canada and the Attorney General of the province so that they can be heard on it.
But the Court of Appeal goes rogue all the time, Kyla. Like, the Court of Appeal, look at the sorry, it escapes me now. The recent decision on evidence to the contrary in IRPs, the court went off on a complete tangent about what evidence would need to be pro-offered in when that wasn't even argued. And the superintendent's report on calculating blood alcohol concentration, when that wasn't even argued, like, just substituted its own considerations.
Okay. Well, anyway, I say the reason the Supreme Court of Canada can do it is because the attorney generals of every province are automatically invited to appear as interveners.
That's true.
So, and on any criminal case, the AGC always does, and many of the provinces often do, at least Ontario and BC.
Yeah.
I don't know. That's maybe it. But anyway, interesting. Supreme Court of Canada will hear this case. Trying to think of a way I can get on as counsel for some sort of an intervener. Can I just be an intervener on my own? Like the intervener Kyla Lee, who cares about impaired driving law?
I mean, I can understand you could probably get in as an intervener with one of those organizations that you belong to. But is this one you really want to intervene on? I mean,
Yes. Because I don't want them to go to the wrong way.
Your argument may or may not sway them. These days, I don't think any criminal defense lawyer's argument is going to sway them on anything.
Okay.
That's just the way I interpret things at the Supreme Court of Canada these days.
Well, I do like
our courts have become more and more conservative as when baby boomers got on the bench.
I do like the framing, though, of it creating a de facto absolute liability offense or a situation of substituted mens rea. I do think that that's a smart way of looking at it outside the constitutional question.
But the liability is not the issue. It's really a punishment scheme. I mean, it's that the offense is still committed, that you're driving while impaired. Okay. It's just that the injury or death is not connected to the fact that you're impaired in the scenario that we've talked about.
Go ahead.
No. So I mean, I just like it's incidental. It just is it's a sentencing provision essentially that isn't connected to the actual wrong that you committed.
But there's no mandatory minimum period of incarceration. Like obviously incarceration always happens because of the range.
It creates a sentence. Yeah.
You can get a CSO, right? So because there's no mandatory minimum, arguably, it's open to the trial judge in those cases to impose a sentence that more closely aligns with the de minimis offense.
Well, I would say don't add me as an intervener because I will not argue as well as clearly you do.
Well, as an intervener, you only get 5 minutes, so really it's hard to make a developed argument anyway. All right. Next, we have a case out of the Saskatchewan Court of King's Bench, which is about a situation of... Oh, sorry, that's not the case I meant to talk about. Apologies. That's on me. Sorry. Yes, it's a case out of the Saskatchewan Court of King's Bench. Sorry, I don't know why I forgot that was the one I wanted to talk to. It was about the fine case. I sent you this one yesterday and you read it. It was the case where this guy gets charged with like violating weight restrictions under the Highways and Transportation Act in Saskatchewan. And then he is charged a fine. And there's an automatic mandatory victim fine surcharge attached to the fine. And he argues, hey, wait a minute, that's unconstitutional. You can't add a victim fine surcharge without having the opportunity to, like, ask for it to be canceled.
Yeah. I mean, and the whole circumstances are actually so sympathetic because he's a truck driver. I think he's like relying on GPS or something. He turns down the wrong road by mistake. It turns out it's a road that's not permissible for trucks of that weight. He figures it out almost immediately, turns around and goes to drive away and is stopped. And the fine amount is like in the tens of thousands of dollars. I think it was $16,000 in total or something, or was it $16,000 plus the victim fine surcharge? Like it was
$15,985, and then there was also going to be a $6,300
victim fine surcharge.
Yeah.
What is a victim fine surcharge? It's a tax on a fine.
Yeah, basically.
The government imposes the fine. The government puts a tax on the fine.
They said when they originally imposed victim fine surcharges that it would go into a special victims compensation fund, but provincial victim fine surcharges have always just gone into general revenue.
Yes.
It was a lie. But they, as you and I both know, they can do whatever they want with their tax dollars, regardless of what they say.
That's true.
So he argues this is a violation of his charter-protected right to be free from cruel and unusual punishment, because, and the Justice of the Peace surprisingly ruled that it was cruel and unusual punishment, which is crazy because they don't actually have like the authority to consider a constitutional question to begin with.
Well, and it almost seemed like the Justice of the Peace considered it and was like trying to rule the legislation unconstitutional and therefore invalid. That was the sense I got reading the decision, which no Justice of the Peace could do. They could choose not to apply it. They could say that it's unconstitutional and I'm not going to apply it. But even a Justice of the Peace, I don't think has that authority. I don't know what their limits are on charter remedies.
Yeah, I mean, maybe it's
Saskatchewan, it's going to be maybe spelled out in legislation, right?
Yeah, but anyway, so she declines to apply it. She follows the Supreme Court of Canada's decision from many years ago, in Boudreau, that found that victim fine surcharges, as they were under the criminal code at the time, were unconstitutional because essentially, if you didn't pay your victim fine surcharge, there was the possibility that you could be jailed until you paid it, like the debtor's prison, which is cruel and unusual punishment. We don't jail people for being poor. So the court says in the Saskatchewan Court of King's Bench, not so when it comes to Provincial Offence Act type proceedings. Section 12 of the Charter is not engaged in that context. And basically, it doesn't. First, they say Boudreau itself doesn't strike down provincially imposed victim fine surcharges. And also, what happens when you don't pay your mandatory victim fine surcharge in a province? You don't get jailed. You get, like, restrictions maybe on your privileges that are subject to the, constraints of legislation.
Yeah, I was hoping when you sent it to me and I started reading it, I was hoping there'd be some sort of creative, brilliant strategy or argument, some new thing that the judge would have thought of.
Yeah, no.
To strike it down.
The judge didn't like it.
Ridiculously punitive.
The Court of King's Bench judge, and I don't know if it's a male or female judge, but the Court of King's Bench judge did say, I recognize that logical and compelling arguments may be made in favor of concluding the mandatory imposition of a 40% surcharge could result in a disproportionate sentence for a provincial offence. I acknowledge a reasoning pathway that might allow one to conclude the surcharge provisions are unconstitutional, but I'm bound by all of these cases from my colleagues that have all found that it's not unconstitutional and it's not cruel and unusual punishment, so therefore, too bad, so sad, go to the Court of Appeal. Which is what the judgment broadcasts. Go to the Court of Appeal.
Yeah, I mean, well, we had that before too. We've been told go to the Court of Appeal, and then lost at the Court of Appeal. So,
but we have the BC Court of Appeal, and they have the Saskatchewan Court of Appeal. It's specifically Justice Brennan.
That's true. They have the Saskatchewan Court of Appeal. They might get somewhere there.
They are very good in Saskatchewan. Justice Drennan is the one carrying the torch for the rights of an accused person.
I'm always surprised that, government's always framed, this is the punishment. It's so harsh. It's so harsh. We've got the harshest punishment to try and deter people. And yet 40% or 15% of the punishment they don't tell you about. It's the bait and switch. It was like, we're not going to tell you about that because if you did, people would lose confidence in the system. That there's a tax on top of the fine. They only find out at the end. Half the time the lawyer's forgotten to tell them when they get into court. And the sentencing is proceeding. Oh, and by the way, there's a victim fine surcharge. Oh, what is that? Tax on the fine.
Yeah, it's a tax. That's how I explain it to the clients. It's like so hard to explain it what it actually is. It's just easier to say it's a tax, and then they understand.
The tax on the fine.
Yes,
They tax their own fine.
It is like
the provincial governmenting.
Yeah, the government going to government.
Yeah.
Okay, so that's Saskatchewan. We'll have to watch out, see where that goes, whether it does in fact end up as a case before the Saskatchewan Court of Appeal. I hope it does. I hope the Saskatchewan Court of Appeal does find that some circumstances could lead to victim fine surcharges in the provincial context of being cruel and unusual punishment. I think 40% is a little bit insane. What's up with that, Mo?
That's ridiculous. People move to Saskatchewan. They don't know about that.
Yeah. The one time BC is actually a better place than financially than anywhere else in the country.
Well, I don't know about the rest of the country. All I do know is that like the temperature is 9 degrees in Vancouver and sunny, and it's lovely in the interior right now. And all of these places that I've gone to over the last year, driving around delivering liquor and various other purposes, have led me to conclude that I would live almost anywhere in BC rather than living in somewhere that gets to minus 40.
Well, I was talking about financially only. Well, anyway. Yeah.
There's lots of places in BC you can live that are relatively inexpensive.
Quickly, one other thing to update you on before we get to your favorite part of the podcast. Richmond City Council. Remember last week how we were talking about how the city of Surrey wants to use the traffic cameras to spy on people?
Yeah.
So Richmond's been doing this. They installed cameras to spy on people. And somebody smartly filed a complaint to the Information and Privacy Commissioner being like, I'm sorry, this is a violation. The city of Richmond doesn't have the authority under the Privacy Act to collect people's personal information and then just hand it over to police and let police surveil people. And the Information and Privacy Commissioner was like, yeah. So they ordered that the city must stop using the cameras for this purposes. They must delete all recordings and disband the equipment, like harsh order. And they only have until February 26th to comply. So like 6 weeks to comply. They have to provide proof to the Privacy Commissioner that they've complied with the order. So I think Surrey is going to have a real hard time doing what they want to do, considering there's now precedent that says, no, you cannot.
What happens if you disregard the Privacy Commissioner's order?
I believe they can fine you.
I don't know that they can. I looked at this at some point, but I would imagine it would be incredibly humiliating to. What we concluded.
There must be provisions in the Privacy Act that allow you to enforce the order in Superior Court.
I think we concluded when we looked at it that there wasn't. The checks and balances here are you are expected to comply as a level of government.
Well, the city is liable to be sued under the Privacy Act for the tort of invasion of privacy.
I think they could be sued for the tort of invasion of privacy generally on this basis.
Class action for anybody who drove past one of those traffic cameras in Richmond. Imagine, and it's like per se damages, right? So imagine the millions and millions and millions of dollars the city of Richmond would have to pay.
Yeah. Do you know what the court in BC would order as the amount to pay?
$1.
Probably $1. Yeah.
Okay. Anyway, update on that. We'll see. Hopefully they'll comply.
Hope so.
Let's now talk about
the ridiculous driver of the week.
Not a bad one there. You're gonna have to get the details up. I know
This is essentially a person in a golf cart. It was about 2 weeks ago. And they were in Georgia. And the suspect thought that he could get away from the police by hopping in a golf cart. Hold on. Sorry. The YouTube video of it just started playing randomly. I guess it knew I was talking about it. Because it's all on body cam. If you Google like golf cart suspect cops chase, you'll be able to find it. So it's Sandy Springs, Georgia, where the golf carts are. This guy hops into the golf cart, and the police chase after him.
Well, it's like you've watched in the TV shows back in the 70s and 80s, where the police officer grabs some civilian's car and commandeers it for the purpose of police work, where they jump in. This police officer gets in another golf cart and goes after him. And thankfully, like, it looked like, you couldn't really see on the basis of the video, but it sort of looked like the guy working at the golf course pointed him at the faster golf cart, because he did catch up with him. And I mean, I assume the first guy in the golf cart trying to escape from the police had it floored and was going as fast as he could in the golf cart. Golf carts are quite dangerous. There's lots of video of golf cart accidents out there. You and I have a friend who was badly, badly injured in a golf cart flipping. But the police officer does catch up with the guy and manages to stop him on the golf cart.
Just about our friend who got very badly, like life-threateningly injured in the golf cart in 1 minute. I, after found out about this, she was in the hospital for a long time, and I sent a singing telegram to her room, and the singing telegram sang "Hit the Road, Jack" to her.
Yeah.
And if you think that's cruel and mean, you should know that I got text messages saying that I'm a sick fuck, which is like a high compliment from this person.
Yeah. Right. Yeah. She hit the car. She hit the course, not the road. So it wasn't really, too focused on her. Anyway, yeah. So that's a good ridiculous driver.
Yeah, there you go. And that's our podcast. If you have a driving related issue, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com, and tune in next week for another exciting episode of Driving Law.